Oh, yeah. So,
Are we back on the record?
has it been 30 seconds?
Yes, I think so.
I always look at the thing and see, and figure
there.
if that's up, then
Go.
Oh,
are we
okay.
good?
Very good. Special magistrate, for purposes of the city's presentation, we do not have further witnesses. I believe there are 2 members of the public who have not been heard. And we would like to briefly bring those people forward.
Okay.
And-
then that'll be your,
And then we have one final wrap-up, like a 60-second wrap-up.
okay, and then I want to hear from attorneys.
course.
And then, okay, I just, because the question in my mind is when we scheduled this through my office, we're thinking 1 to 2 hours. We're well beyond 2 hours at this point, so
I anticipate
if we
perhaps
can get
30
through it,
minutes.
great. If we can't, we're gonna have to.
Okay.
So let's go ahead and
All right.
hear from your next witness.
Miss Lisa Saywin? Thank you.
I'm the new kid on the block. I just bought the home on Lytle that backs up to the commercial tent weekly.
Ma'am, and I didn't get your last name.
Salwin.
I'm sorry.
I own 728 Lytle.
728, thank you, ma'am, go ahead.
Well, it is, as they say, most of us, I believe, are fully comfortable with Airbnb and vacation away. It's the noise venue from the weekly wedding and the DJ who amps up the crowd and even adds a sing-along as of yesterday evening. And it is a commercial enterprise that is ruining our neighborhood, especially those of us that don't have impact windows that back up directly to this event. But this is my life savings. I'm 65, retired and alone with a dog, and I can't recover if this isn't mitigated favorably. And I know you're here today to review the code violations, but having been a vacation away former entity briefly, this is an educated person who can retain counsel. He clearly knew he was hoping to go under the radar, and all of these violations, if you gave me even put sod in your swill, I'm going to jump tomorrow because I'm afraid of code. So this is not something that should be a worry to him about Saturday's event. He had plenty of time to amp up with the people he can afford to have on the ground because of the stream of income that is coming his way. He's not an impoverished person who can't get counsel if needed. So I don't really feel for this gentleman. I think he sees those circles of wagons coming in on him that he may not want to invest a lot more if he can't run the wedding venue, which is his big moneymaker. So I'm concerned about my homestead, and I'm backing right up to the tent at 728. So my biggest concern is if there will be a statute in the year to 18 months that might protect us from the commercial application, you know, in a residential area. But it is, as they say, it's that application, not the Airbnb and vacation away, that's a disturbance.
Okay.
Thank you.
Before you sit down, Mr. Stevens may have a question or two for you.
Good afternoon. Just briefly, you just said that you believe my client was hoping to go under the radar with these violations. Have you ever spoken with my client?
No,
Okay. So it's an assumption you're making that he wanted to go under the radar with these issues?
the obvious avoidance of securing the appropriate licensors lets me know that this is the case. There's no way I would have not known. I would have looked into it if I was going to run something of this magnitude.
Okay. And you said you're comfortable with his property being used as an Airbnb to rent to third parties, is that right?
Not for parties, just
I didn't
a
say-
standard vacation away Airbnb residence for people on vacation.
Right. So again, I didn't say for parties. I said specifically if you wanted to rent his property to third parties to be used as an Airbnb, you don't have an issue with that, right?
No, I do not.
Okay. Thank you. I don't have any further questions.
Thanks.
Thank you, ma'am.
Next member of the public, sir, is Ann Lynch. And I apologize, I may have told you there was 2. It's actually 3. Apparently, I couldn't count.
Good afternoon. My name is Ann Lynch. I am the person that was identified and accused
What
on
is your address?
721 Winters Street. I was the one who initiated the code enforcement investigation after I was able to determine that we were going to be subjected to weekly weddings. And I just want to make sure that you are clear, you probably are, but all of the wedding receptions are held out of doors. There is no facilities on this property for them to have wedding receptions inside anywhere. And they all involve amplified noise. I live across Forest Hill Boulevard, behind another property. I'm on Winters Street. I have impact windows, and I also have, in the past couple of years, invested with appropriate code enforcement and inspections and permits, almost $180,000 into my property to have a beautiful backyard and a pool, which every weekend now, except for last weekend for some strange reason, there is a very loud, miserable wedding reception with thud, thud, thud that you can hear inside my house with all the windows and doors closed with impact windows. And I'm not just right behind them. I do resent being characterized as harassing. Harassing may be that I went and inquired as to why they thought that they had the right to have this. I also was a past president of the neighborhood association, and I am a retired attorney. So I have the time, and I have the inclination to try to keep our neighborhood as best we can in a enjoyable, peaceful environment. And the idea that I can't approach the property manager, who is the one who's committing is doing all of this behavior. If this guy is out of the country all of this time, clearly the property manager, Brianna Ford, she is the person that I made contact with. She is the person that is renting the facilities. She's on site at every wedding reception. She's the one who comes out to the sidewalk to harass me and ask the police officers that are off-duty, private overtime police officers, to harass me when I am well aware of what my rights are under the law as far as First Amendment and being able to be on public property. That being said, this is outrageous what this neighborhood has to be subjected to. And there is absolutely no attempt in good faith by these owners to rectify any of these things. It started with all these accusations against me and harassment right off the bat, that I violated a trespass warning, which I did not. The argument seems to be that it's just that it needs to be brought into compliance. But if the business model is a commercial business that happens every week, and a commercial business is not allowed because of the zoning, what difference does it make whether the permits can be brought up or the violations can be brought up? I understand that that things have changed with online advertisement for these kinds of activities, and it makes it a little more challenging, but there's absolutely no way that they can claim this isn't a commercial business when they have, in their own words, in that probate pleading that you have that is signed by the owner, he specifically says that this property is for commercial purposes. His own online advertisement specifically says it's a wedding venue that can accommodate up to 125 people. There's no parking on site, which means they're all through the neighborhood with valet. This in itself is a danger to the neighborhood when you have people who are drinking and there's no regulations, there's no compliance in any kind of rules that would ensure that people would be safe even leaving the property. So there's no indication that these people are going to try to comply. They haven't done it yet. And it's obvious from their own calendar. They have this property booked on Airbnb every weekend through July that I could see. There may be 1 or 2 weekends when they're not booked, but if you think about wedding venues and how much it costs to put on a wedding, and they haven't had to comply with any of the regulations that any regular venue would have to do. So they're making quite a bit of profit, and they probably have contracts with all of these wedding parties. Invitations have gone out. This is a big problem for them because they decided to have an illegal commercial enterprise. So they're very motivated to keep, as they did last night, continue to have all of these parties completely disregarding the needs of little children that could be trying to go to sleep right on the other side of that wall behind them. I mean, this is just outrageous, and I really would appreciate it if you could do something to help us. Thank you.
Thank you, Ms. Lynch. Mr. Stevens may have some questions for you.
Thank you. Good afternoon, Ms. Lynch. You and I have spoken before, right?
We spoke once, yes.
Right. And you recall during that phone call, I believe it was back in January, right?
Yes.
Okay. And I expressed to you my client's desire to try and make sure that none of his neighbors were in a place that they were being bothered in any way by this more than what was reasonable, right?
I don't recall you saying that, and obviously he has absolutely not done that, so I'm not sure why that would be relevant.
Okay. So Ms. Lynch, again, you've approached this property a number of times over the last 2 months, isn't that right?
I have not gone on to the private property. I have, every chance I get that when there's a party, I go down there and I use a decibel reader to be able to read the volume of the noise, which has been between 65 and 85 decibels when there's a party going on.
And have you saved those records?
I have them on my phone, yes.
Okay. Have you taken those readings at your own house?
Yes.
Okay. And what have they shown at your own house?
They're not that much different, surprisingly.
Okay. Ms. Lynch, I'm going to show you the document. I'm going to go ahead and give it to you, but also, I've only got one for me. Show the dimensions, it's just the number. Ms. Lynch, does this look like a map of the area that we're talking about right now? Our property being the property at issue in this case?
Yeah.
Okay. And you see I've got a little arrow drawn towards 721 Winter Street. Do you see that?
Yeah.
Okay. And I believe you just testified a minute ago that that's where you live, right?
Correct.
All right. So your testimony today is that from where the property is located across the street on Forest Hill Boulevard, past another house that you're in between, that you have a device that measures audio that registers approximately the same amount of audio from your home as it is right in front of the property at issue in this case?
Yeah, in the backyard, not inside my house, obviously.
Okay. In your house, can you hear anything?
Yes, I can, even with the impact windows.
Okay. Now, Ms. Lynch, as you have approached this property, you've had several conversations with my client's property manager, is that right?
I actually believe I only had, I had one where I asked her what authorization she had for having weddings. That was the first time I met her. After that, she would come to the gate while I stayed on the sidewalk and confront me and make statements about me harassing people. She didn't like that. She didn't like me being there. She didn't like me talking to people that were on public property. And I can understand that because I'm actually, questioning why she should be able to have this very lucrative illegal business.
Ms. Lynch, isn't it true that you represented yourself as an attorney that was the president of the neighborhood association to my client's representative on the
I
property?
was the president of the neighborhood association.
Okay, so again, isn't it true that you represented to my client's representative that you were an attorney and that you were the president of the neighborhood association back in January when you were complaining about this to her?
Yes.
Okay. Now, I'm going to show you a note that I have been told you gave to her. you seen this note before, Ms. Lynch?
Yes, I have.
Okay, did you write that note?
Yes, I did.
Okay, and on that note, it lists that you're the president of the association, right? The neighborhood association.
Right.
Okay, is there an association for this neighborhood?
Well, I was the last legitimate president of the neighborhood association. The association is basically defunct at this point, which, you know, it is what it is.
Okay, so you weren't
I am
actually-
the one who informed the rest of the neighbors, and I still do try to maintain that role as best I can.
I understand that, but at the time you wrote this note to my client's representative, you weren't actually the president of any neighborhood association, were you?
I mean, it could be argued that I still am.
Okay, well, you also told her you were an attorney, right?
I am an attorney.
Okay. In fact, you gave her this card, which says you're an attorney of the law, right?
Yes,
Is this your card?
yes.
Now, Ms. Lynch, isn't it
She
true-
asked me for that card. Yeah.
Fair enough. Ms. Lynch, I understand that you just said that you can argue that you were the president of an association when you gave her that note, but isn't it true at the time you presented yourself as an attorney to my client's representative, provided that card to my client's representative, and signed that note that you are actually not licensed by the Florida Bar presently?
Sir, I am,
Magistrate, objection in the interest of time. This is not relevant as to whether or not the property is in violation in any way whatsoever.
well, I am an attorney in good standing, although I am inactive with the Florida Bar.
Ms. Lynch, I'm going to provide you with a copy of the Florida Bar profile of yourself. Ms. Lynch, doesn't that document say that you are not authorized to practice law in the state of Florida?
I don't see where it says that.
You've got my only copy. Top right, not eligible to practice law in Florida.
Yeah, I just said that I am, what did I say? What's the word for it? Inactive. I am inactive because I am retired.
Okay,
And I
but-
think I said I was retired when I first got up to this microphone.
You did say that, but you've also been representing that you are an attorney. in the
I
state
am
of
a
Florida.
trained attorney, sir.
Okay. Now, with respect to this property, have my clients done something to upset you other than having weddings at their property? Have you personally met my client?
Sir, your client has made my life miserable every weekend by conducting a commercial activity of very loud wedding receptions in a residential neighborhood.
Ms. Lynch, I understand that. Have you met my client? Have you met Mr. Castellanos?
Well, since he's never in the country, I'm not
You
going
can
to be
say
able to
no.
meet him.
You can say no if the answer is no.
Well, if he's never been in the country, what does it matter? The fact is that he's got a property manager that's conducting all of this business. And I have met her, and I have raised my concerns with her, and my concerns have been completely ignored. And then you had another party last night. And you have the nerve to come in front of the magistrate and try to say you're trying to be in compliance. You haven't done anything except make more money and ignore the needs of the neighborhood.
Okay, Ms. Lynch, when we talked, I discussed that there were a number of remedies available to everybody to deal with this stuff. But you have chosen to come close to the property, come onto the property, and even have very aggressive conversations with guests coming into the property. Isn't that true?
Sir, don't you think I have a right to be on public property and to record or determine or to gather evidence to be able to come in front of the magistrate and share what is actually happening there?
So you think it's appropriate to yell at brides as they're coming onto the property and stuff paper into their cars as they're coming onto the
Sir,
property?
I'm sorry, were you present when that happened?
Okay, I'm gonna, I don't need you guys going back and forth. You can ask the question, you can answer the question.
If you didn't do it, you can say you didn't do it, and that's your sworn testimony today, and we can deal with that later. But I'm asking you today, are you saying that did not happen?
Yeah, I'm saying that did not happen. I never yelled at anybody.
Okay, all right. All right, I don't have any further questions for you, Ms. Lynch. Thank you.
Final person from the public, sir, is Mr. Bill Nugent.
Good morning. Bill Nugent, 1707 Florida Avenue, West Palm Beach. I'm a 30-year resident of the city.
Yes, sir.
I'm not here to be a witness, if you will, of any facts. I'm here to give a little bit of a different perspective. I've served for many years as the vice president of my neighborhood association, which is north of where this is occurring. I'm not been to this property. It doesn't personally impact me in terms of the noise. In terms of my business, For decades, I have restored, owned, and operated small and medium-sized apartment buildings, and more recently, vacation rentals in the city of West Palm Beach. I am here in support of my fellow citizens, residents of West Palm Beach, and also because when I see businesses that operate in such an incongruent way with the context or the area that they exist in, I find it to be irresponsible, and it damages my business category. It's what I read about in the paper when I hear about this vacation rental or that vacation rental showing up and having these big parties. I operate things in a responsible way. I have all my licenses. When work needs to be done, I always have permits and inspections. And this is really troublesome to me when I see other businesses operating in this type of way. So I just wanted to give a different perspective on this.
Thank you, Mr. Nugent. Before you sit down, Mr. Stevens,
No
no
questions?
questions?
No
All right,
questions.
thank you very much. Any other witnesses from the city?
We have Mitch Posner as a final sum up on the actual violations. We've gotten far afield from talking about those, so he's just going to take just 2 minutes to wrap it up.
Okay, first there was a suggestion that they may try to dismiss 94-272B as ambiguous. 94-272B specifically refers to a permitted use table in the code. Wedding venues is not on that table for this location, period. There's nothing ambiguous about that. They've referred to all their communication as an attempt to comply with this, but bottom line is it's been about their bottom line. They've continued to hold these events, continued to disturb the neighborhood, as you've heard time and again from here, and that has to stop. It's not intended for that use. It's being used as that continually, whether they have something after this weekend or not. They even refused to cancel this weekend in an attempt to continue this. The owner hasn't even made time to be there. We have conflicting information as to whether or not he's in Amsterdam for his child or in Portugal, as he's apparently posting online. They haven't even brought the property manager here for this. In summation, in accordance with Chapter 162.09D, where such fine shall not exceed $1,000 per day per violation, the city is requesting $1,000 per violation per day starting today. The reason starting today is 162.06. If a violation of the codes is found, the code inspector shall notify the violator and give him or her reasonable time to correct the violations. At this point, there's certainly been more than reasonable time to simply stop advertising and stop holding these functions, which would have complied with the violation. And 162.074 refers to the magistrate's order, which may include a notice that can be complied with a specified date. While that is often a general practice, it's not required. We're asking the fine start today, $1,000 a day per violation.
Question not completely related to what your testimony, but refresh my memory. At the beginning of the hearing, Mr. Lopez testified that one or two code sections. At the beginning of the hearing, Mr. Lopez testified that one or two had come into compliance. Can you remind me what
Yes,
that testimony was?
Alex Lopez. The code sections that did come into compliance are sections 18106K and 74.4C4.
Well, good. That matches up with the notes on the code sections I didn't remember getting testimony about.
Okay.
So they're in compliance. All right, let me go back to Mr. Stevens. City's concluded its case.
Okay. Before I begin argument, can I move, you want to handle the motions to dismiss on certain points?
You may.
Okay. Magistrate, I would move to dismiss violation 94-272B, as well as 94-6 on the citation that was issued. The first page concludes with specific details regarding each violation. The first page has a list of the 1, 2, 3, 4, 5, 6, 7, 8, 9 violations. And then below that, the city has created this document to give notice to my client of what the details are regarding each of those violations. And so if you follow on to the next page, the 94-272B and the 94-6 details for those violations, which again is what gives my client notice of how to prepare for today to defend himself and actually prepare a response, references the erection of tent structures and equipment on the lot for public and or private use of the events, venues, etc., is not permitted per the Planning and Zoning Department. You know, I don't know if they're planning on relying on the et cetera to fit in everything that they've been talking about, but when I asked Mr. Lopez originally about this, if this was just about the tents, I read this just being about the tents. If there was something else that needed to be in there, it would have been really helpful to my client to know what else they were claiming somehow did not comply with the zoning or planning or whatever it was. But he did go out of his way as soon as he got that to try and rectify both of those things. And you've heard testimony that the city is not disputing that he did go ahead and apply for tent permits immediately. And they've been getting issued. He's even got one in place for this weekend, for the wedding this weekend. So to the extent that they are still pursuing those for anything beyond the tents, because if it's just the tents, then we've satisfied that. If it's anything beyond the tents, Your Honor, I would suggest to this tribunal that is beyond vague and ambiguous as to what he's being alleged to have violated, and I think that due process would dictate that he's not on notice for anything beyond that, and those two violations should be dismissed.
Okay, let me hear from the city.
The city would obviously object, and the characterization that he's on notice for only the tents, it does indicate in the recitation venues, and that would include advertising and holding this property out as a wedding venue and commercial going concern. So the city would object to dismissal of either of those two violations or citations.
Just give me a second, I'm looking for something in my notes. All right, I'm going to deny the motion to dismiss for vagueness. I'm going to, I believe that the code sections as cited put the respondent on proper notice of what was being alleged to be in violation by their own terms, so you can proceed.
Okay, so just, that's their closing. Is there any more argument from them, or that's?
That appears to be their argument, I'm denying the motion.
Okay, very good. All right, magistrate, if I had my client here today, I think I'd be able to paint a clearer picture of the efforts that he's made to try and bring his property into compliance with the alleged violations that have been pinned against him. Yes. The minute that the citations were issued.
Actually, let me, before you begin your argument, let me just a little bit of housekeeping, because we have a number of documents that I want to either get on the make part of the record. First was the binder that Ms. Ramirez provided. which it looks like it includes a lot of the documents that were in the city's file already in terms of the permit applications. There were some photographs. There were vacation rental booking pages. Then there was the tab that included the complaint regarding the estate of Paul Migliori, and that had the complaint and the exhibits that go with that complaint, where she had highlighted a number of places in the documents that referred to the intent on how the property was going to be used. There's another tab with some additional vacation rental pages. There's a tab with a case called Bennett versus Walton County, which has some highlighted language that deals with use of property. And finally, there's a tab with a photograph, 2 photographs, which appear to be taken from her property over the fence onto the respondent's property. Is there any objection to those documents being made part of the record?
I mean, I would object to anything that's not authenticated.
I beg your pardon?
Anything that's not authenticated, as far as, I would consider it all hearsay.
Okay. Thank you. Any objection from the city?
No objection, because it is something that the public has submitted, and I think the special magistrate is entitled to see what they want to submit.
Okay, yeah. Over that objection, I'll accept the documents into the record, and what weight and credibility they're deserving, I will determine. But the rules of evidence are not applicable to this hearing, so I will accept those into the record. The next document I wanted to talk about was the rental tax application certificate of use. That may already have been part of the city's file, I don't know, but it was specifically provided at today's hearing, the 2-page document dated January 14th and showing the 4-unit rental property. Is there any objection to that, either being made part of the record again or being made part of the record?
City has no objection.
Any objection, Mr. Stevens, on that one?
No, magistrate.
All right, that'll be made part of the record. And then finally, we have the documents that were discussed during Ms. Lynch's testimony. There's the printout from the Florida bar, the photo of the business card, the handwritten note, and the map with the arrows on it. Is there any objection to those 4 documents being made part of the record?
Nope.
Again, no objection. You have Ms. Lynch's comments regarding those.
All right, then those documents will also be made part of the record, and I apologize for interrupting you, Mr. Stevens. I just wanted to take care of that before I forgot.
Okay, no problem. So kind of to start at the top and work our way backwards, the testimony that we heard from the city employees and the witnesses was that it's not that he can't do what he's doing, he's just not doing it the right way. They may be coming up with different ways in the future to limit residents to use their properties, as my client has in this case, but we're all bound by the laws as they exist right now. And right now, the laws exist in a way, and again, the testimony was they're working on it. They haven't come up with a solution for the laws that allow my client to do what he's doing, but to their point, there are things that need to be done ahead of time before he can do this. And we're not arguing with that, and since he got cited for this again, I've done my best with my one-man show over here, trying to show that my client has made a diligent effort to try and comply with all this stuff. But he has applied for the dwelling permit. He has obtained a sales and use approval from the state of Florida since this happened. He went ahead and got a vacation approval from the state of Florida. That's all filed with the city now. And so these are all little things that he's done. He's applied for a tent for every time that he's had an event at his property. he can do what he's doing right now if he does these things right. But the big hang-up has been, and what has prevented anything from actually getting completely fixed before today, is the nonconformity of this property. One thing you didn't hear today, and it is not evidence in this case, is that those nonconformities existed because of him. There wasn't anybody. I asked everybody that got up here if they had any evidence to show that that he did this, or if it was something that was already on the property but when he got it. I'll submit to the court that it was there before the property, but what I say isn't evidence. And again, if I had my client here, he'd be able to tell you that himself, but because of his child, he was unable to be here today. So with respect to that, for example, the stop work order cites a quadruple penalty against him, which is totally inappropriate, as the testimony was, because they have no evidence right now that he was the one that caused the nonconformity. And he's willing to work through these nonconformities. He's been in constant contact with the city to work through that. But it is a process to figure out, even as we sit here understanding what some of these citations are as to what he needs to do to fix everything, it is not as simple as just pulling the trigger and we're all fixed. And so he needs time to be able to fix that nonconformity. That we'll concede. All right, there's no issue about that. But so much of what's on this list right now is tied to that. He can't get the certificates that he needs. He can't get the license that he needs because the city has found a nonconformity that he didn't create in the first place, which caused a catastrophic domino effect of everything else, which leads us to not have everything fixed before you today. And in turn, again, we try to be transparent with everything. Every event that he's got going on, they asked for it as part of the review of everything that was happening. He provided it to them. He gave them a list of every time we were going to have somebody. Today, we've tried to be as candid as humanly possible about what's coming up because, again, we want to do it right by the city. And if he's allowed to do it, then he wants to do it right. And if he's not allowed to do it, then that's fine too. But at the same time, from all the testimony we've heard today, it's not that he's not allowed to do it. It's just you can't have 4 stoves when there should only be 2. And then therefore, I can't give you the certificate until you get 4 stoves to 2. So he's willing to work through all that. He's willing to work with the city. This whole thing kind of started and it kind of came up, as Ms. Lynch said, because she's the one who started this whole train. She was very upset about it. I called her at the very beginning. She testified to that to try and just be like, what's going on? How do we fix this? Is it too loud? Please let us know. And this whole time, it's just felt like there's something else going on with that. And I don't know what it is, and it's very difficult for me to understand. But Ms. Lynch is very upset. I don't think anybody's going to argue about that. But at the end of the day, we're all still bound by these rules. Hands down. I'm not trying to argue that we're not. And my client is trying to comply with these rules. And there really isn't anything in the citations that says he can't operate an Airbnb there. I think the testimony was that he can operate an Airbnb there. And that's what he's doing. And if his guests that stay there want to go ahead and throw a wedding there, then, if they want to create rules that prevent that, then so be it. That's fine. But right now, there's no limitation on event permit applications that can be submitted. They've testified that there's no limitation. If they want that in the future, they can have that. And then my client, just like every other resident in the city of West Palm Beach, will be bound by that fact. But today, there isn't a rule and there isn't a limitation. And so he should be allowed to do this, so long as he fixes the nonconformity, which would then allow him to get all that other stuff done. Now, we would just ask for a sufficient amount of time to get that done. I mean, again, it's not entirely clear what needs to be done. We don't want them to come in there and then say, oh, we got 10 more things you want to do, and then suddenly it's like we've gone from this one nonconformity to 15 nonconformities. They've already done their inspection. So again, if the magistrate, if you are going to require those to be fixed, which I don't see anything wrong with that, we just want sufficient time, and we would want something in there with the language that the city has to be diligent in responding to inspection requests and in responding to inquiries from us that would allow us to understand what we need to fix, so that way we can make those applications for the certificate of use and the vacation rental. I would take issue with the request for the fine. Now, the notice that was issued that we're here today on specifically states at the end of it that if the special magistrate determines that any violation exists, he or she is empowered to impose fines of up to $1,000 per day for each day that any violation continues to exist beyond that date. It doesn't say for each violation. It just says at most a property owner can be fined $1,000 per day for each day a violation exists. Now, magistrate, a property owner needs to be given an opportunity to correct and cure the issues that are on his property. You've heard the testimony from everybody that has spoke with my client, that he has been in constant contact with this city to try and resolve these issues. The one with respect to the nonconformity, it's going to take a little time to get fixed. Once that gets fixed, there needs to be an opportunity for him to resubmit the applications with the nonconformity not present. If the fine begins immediately today, he's put in a position right off the bat of not even being able to try and get this fixed, not at any fault of his own, but just because it takes time to get this stuff done. And so, magistrate, if you're going to find violation with respect to anything on this list, we would ask that a fair amount of time be allowed for my client to resolve the nonconformities and to deal with any of the other violations, and that if those are not cured by that time, then there would be a certification hearing on the fine, and at that point in time, would he be subject to a fine.
Do you have a sense for, assuming immediate and good faith forward progress, do you have a sense for how much time you think it will take to cure those, the building code, the big violations in terms of structural and permitting and that sort of thing?
I don't, because it could be as simple as removing the stoves. But I know that the wiring related to those stoves has to come out too. And in order for them to remove the wiring, they need to submit for a permit on that also. So the city would have a better idea of their process and how long it would take to do that. So my concern is that primarily is if we're going to remove the stoves, which he'll do right now, but it's the wiring related to those stoves that is the cause for concern, because he doesn't want to do that without a permit, because then we're right back where we are right now of him doing stuff that's not appropriate. So I don't know the answer to that. And the other point is the turf. He's using recycled turf. The city doesn't have a program in place or a process in place to evaluate whether to accept or not accept recycled turf. And so he's working with them to try and come up with a way to get this done where he's satisfying the city, but at the same time, there really isn't a process in place, so I don't have an answer for that one either.
Okay. Before I hear a final argument from the city, let me ask Mr. Brown, do you have a sense for, based on what you know about this case, again, assuming immediate and good faith forward progress, what's a reasonable time to get that work?
Okay, so the representation here is that it's simply a matter of taking out the ranges and taking out the wiring for those, but there's also the matter of more than $130,000 worth of money that's been put into the property by the respondent for work that may or may not require permitting, and I have reached out to the respondent via email and offered that we can meet with him or his representative there to walk the property with them, to tell them what requires a permit and what doesn't. That we haven't been taken up on that offer yet. So it's difficult for me to say how long it's going to take without knowing the magnitude of the issue, how much work was done by the respondent, how much work was done by a prior owner, if it was done by a prior owner. And so that's not something that I can say with certainty how long it'll take. Architects' plans will be required, submitted to us for permit review. We typically will review plans in two weeks. But if the plans do not comply with the code, then of course there are comments that go back to the architect and there's a resubmittal process. Now the respondent has been aware of this issue because the respondent is claiming compensation for the work that they've done on the property.
Okay, thank you, Mr. Brown. All right, let me hear from the city.
Thank you. Just briefly, this appears to be a situation where this property owner has put the cart before the horse. And he's kind of handcuffed his own wrists here by doing things a bit out of order, going forward, holding himself out, and inviting people to come and rent his apartments by inviting them with a wedding. You want to have a wedding here? You have your wedding here. Oh, by the way, you can stay here too. So we do have a person, a property owner, who appears to be doing this on the backs of the rest of the surrounding public and potentially putting the public and his guests in a situation where there could be, and maybe, I don't know, a health, safety, and welfare concern. We don't know because we haven't been able to do all the inspections, as we've all talked about, and get all this into conformity. And again, he's bought this property subject to whatever was there. I get it. And again, I think when building or any of our other officials go in, do the inspections, they'll find what's wrong, they'll find what may be okay. Granted, the problem is that, again, Mr. Katsouris appears to be profiting off this community in a place and in a way that is not permitted. Again, the city would submit that a wedding venue is not a permitted use in a residential area, and he's very clearly holding himself out, continually inviting people in to come and hold their events there. And he could very well have, for instance, on the turf, before you install turf, check with your city. But instead, it seems to be a install and do and ask for forgiveness later. And thus, this has been going on, actually, the wedding events have actually been going on much longer, apparently, than even in January when the city found out about this. That's based on looking at the internet, that's based on some emails from Joey himself. So he came in, he started doing without checking, and it's the city's burden and priority to make sure that it protects its citizens and those guests that might come in, to make sure that they're not put in harm's way because things haven't been conformed the way they need to or inspected, etc. Again, based on the fact that this is recurring with so many people, 80 to 100 to 120, it really is a health and safety concern. And it's been very disruptive, and you've heard a lot of testimony here. I understand that, opposing counsel indicates his client wants to do right. I don't doubt that. I don't doubt the desire of this city to work in good faith with them. The city does not plan to drag its feet in any manner. But the city is beholden to its code to protect its citizens. And one way of doing that is to go through this process today and to go forward with fines. And Mr. Posner can address a couple of specifics in that regard.
Well, for starters, he mentioned the city's case is that he was not that he cannot do what he is doing with the weddings. I disagree with that. My testimony itself, which wasn't until the end, was wedding venue is not on the permitted use table, period. The licensing supervisor testified that they would not be issued a COU or a business tax license for a wedding venue. That's what they've continued to advertise it as. They've continued to point out who did or did not make the illegal conversions of the other two units. It's not relevant. He owns it now. He's the responsible party. And he did make, as we heard, testimony of over $100,000 in changes on this property that we're not even sure what that was at this point. It could have been that. Maybe it wasn't. He said that there's no limits on special permit applications. That's not true. The city code does say that the permits could be denied based on the circumstances, discretion of the city. And if there's continued complaints and continued problems, I can certainly foresee that happening. And he said he needs more time to comply. It takes no time whatsoever to stop having events and to stop advertising as a wedding venue and to stop advertising as a rental, which is what the code says you have to do to comply. He could have done that at any time. They've had more than sufficient time. We repeat, we're asking for $1,000 a day per violation. And one last point, he mentioned that it wouldn't be due process to do that. Special magistrate determines that any violation exists. He or she is empowered to impose fines of up to $1,000 per day for each day that any violation continues to exist. I haven't been to law school, but the way I read that is that could easily be per each violation.
All right, then, Mr. Stevens, I'm going to give you the parting shot.
Thank you, Magistrate. The testimony that we heard, while it might be different now in argument, was that if he rents this place out as an Airbnb, which our position is that's his primary use for this place. It's not, it's not a party venue. It's an Airbnb, but it's a nice place to throw a party. Fine. All right, we get that. And that's why people stay there, is that they want to be able to have that benefit while they're there, and they do. But his primary practice is to have this as an Airbnb. That's where he rents it out. That's the testimony. You've heard that the neighbors don't care if he uses it as an Airbnb. You've heard that if he were to rent this out to a third party and they were to throw a party, that those people could apply for a permit and for a special event, and that there's nothing in the code right now to prevent them from doing that. There's this conversation about money that he invested, over $100,000 of money that he invested into the property. There's no competent evidence about that. There's a piece of paper floating around from a probate proceeding that I think people are referencing to. Nobody's talked about that. Again, that would be a hearsay thing. Our position would be obviously that he's willing to make the changes that he needs to make. But at the end of the day, that this is something that is permissible under the code. That's the testimony that's before the magistrate today. And so we would ask that, again, to the extent that a violation is found for any of these, that a fair amount of time is given for him to make the corrections. And again, once that time has passed, if he hasn't made the corrections then, at that point, to impose a fine to the extent it's necessary. Thank you.
All right. This is going to be an interesting order. You will just bear with me for a few minutes while I take a quick look at my notes.
Special Magistrate, once you start pronouncing,
Yeah.
we need you closer to the microphone.
Yes.
Yeah.
Okay. All right, I'm going to... So first of all, I do find proper notice in this case. Respondent is represented by counsel. There was a motion to continue, which was denied. The motion was denied. Because my condition for continuing it on maintaining the status quo with no further events until the hearing occurred could not be agreed to. So we proceeded with the case. I have heard all the testimony from the city's witnesses as well as residents of the neighboring property. I've reviewed the documents that have been made part of the record. I do find, based on the testimony and the evidence, that the property has complied with 106K and 74-4C4. Those are the violations that were alleged that regarded the vegetation and landscaping. There was testimony that those were complied, so I will find the property is in compliance with those violations. However, I do find the property remains in violation of the other code sections that were cited in the notice of violation. And I want to expand on that because, based on the testimony that I've heard, not only from the city staff, but also from the residents, the neighbors, I believe what's occurring there does rise to the level of impacting their quiet enjoyment of their property and thereby impacting the public health, safety, and welfare. Given that, I say that now because I think it's relevant to the denial of the continuance. I think that this type of a case does not lend itself to being continued because the respondent couldn't be here, especially when the respondent wasn't here, admittedly, for any of the events that really are the crux of the code violation. It's very clear, there seems to be no argument that the property has building code violations, and quite frankly, whether they were caused by this respondent or the person that this respondent purchased the property from. For my purposes at this code compliance hearing, it doesn't make a difference to me. Whether that impacts how the building code process goes and permit fees, that's a different matter that's outside of my authority to rule on. But there seems to be no argument that this property is properly zoned and properly constructed as having 2 residential units, and it's very clear that it has 4. That needs to be fixed, and that is what's holding up everything else, in terms of a rental license and a business tax receipt and the certificate of use. But even bigger than that, from the testimony that I've heard, it is clear to me that this is being used, and it's being used regularly beyond a simple short-term vacation rental. Folks come in for the weekend, enjoy the property, enjoy West Palm Beach, and then go back home. This is testimony made it very clear to me this is being used regularly as a party venue, whether it's a wedding reception or whatever. That's how it's being advertised. That's how it's being used. Multiple neighbors testified about the noise that they're suffering through as late as 2 o'clock this morning. While I appreciate that the respondent, based on the arguments of counsel, and there was testimony about email correspondence and permits being applied for, is trying to get to the right side of this, I tend to agree with the city attorney. I think that he has put the cart before the horse. Whether he made the changes to the property or whether that's how he bought it, when you're the owner of the property, you need to make sure that it is in compliance with the codes before you start using it however you're going to use it. The testimony that I heard indicated that even if the 4 units were converted to 2 and the business tax was paid for, that this recurring wedding event venue would not be permitted in this zoning district. So I don't see how there's any relief that I can grant to the respondent that would allow that to happen. From what I heard, there is no special event permit that could be issued for that. So I do find the property is in violation. I'm going to be very clear that in terms of the use, that needs to cease and desist immediately. I agree with Mr. Posner. It takes no time to stop doing something that's not allowed to be done. And so in terms of unpermitted special events, that needs to stop. And quite frankly, we're talking about something that hasn't happened yet. I think that any future event could arguably be considered a new violation that is irreparable and irreversible in nature, and the penalties that are associated with an irreparable and irreversible violation could be argued in that case. I'm not judging that hypothetical case. If something happens and the city sees the need to bring that case forward, should it happen, that's and it falls into my lap, I'll be happy to rule on that case. But my order today is that the unlawful use ceases immediately. In terms of the building permit violations, the 105.1 and the 110.1, I'll allow the respondent 60 days to work with the city, obtain those permits. I don't expect that the work will be done within 60 days, but I would expect that there shouldn't be any reason that building permits cannot be issued within that period of time. And after that, those issues would then be under the Florida Building Code and the building permit requirements and timeframes, but it would take it out of the code enforcement realm. Failure to comply with that 60-day time frame, I will impose a daily fine of $1,000 per day until compliance is achieved. And that includes the artificial turf as well. I think that should be sufficient time for the respondent to get the artificial turf in compliance. I mean, you can, as the building official testified to, that can be complied by putting in real grass. And that shouldn't take 60 days if that's the worst case scenario or that's what has to happen. So, and the same $1,000 a day for that violation. I want to make sure that I'm being very specific on these code sections. You know, in terms of obtaining a tent permit or a special event permit, I'm not sure there's anything that I need to rule on that. If the property is brought into compliance with city codes in terms of the structures and the land and the artificial turf, and then the applicant would be, or then, I beg your pardon, the respondent would be free to apply for a rental license and comply with city codes in terms of what can be done with an Airbnb and apply for whatever other permits, and we'll be under that permit process. But I don't think there's anything else I need to do in terms of that piece of it, because I am saying cease and desist the special events that do not have a special event permit right now. Let me ask the city, does that cover the case? Did I miss anything in terms of what I want in the order?
The advertisement alone is part of the violation, so even if they're still advertising, it's not just special event, they're still running a business without a license.
And again, my order is on that is cease and desist immediately. No unpermitted, if there's no business tax receipt if there's no certificate of use, then you can't run that business. There's no time to comply on that. Stop doing it until you get the business tax, because those permits aren't going to be issued until the building code work is done. So,
Are you saying there's an immediate fine if they don't cease?
okay, so that's what I'm wanting to make sure I'm covering everything.
And on the advertisement, that we're getting into First Amendment issues there.
I'm not ruling on the advertisement. I'm not making a finding on what you guys are posting online. What I'm finding is that how the property is being used and how the property is existing in terms of the structures that are on it. So I guess that gets back to my I need to modify what I said. So any unlawful use of the property would be $1,000 per day for each day that occurs, which I guess is still the same as cease and desist immediately. But if you don't cease and desist immediately, then every day that you do something contrary to having the proper permits and being allowed to do that, that will be $1,000 per day for each day the violation occurs. Now, you may have to bring that back if something happens in the future, that's not, we're going to have to establish any future violations of those use things, I would think. But for the order for today, it will be $1,000 per day for each day the unlawful use occurs without proper permits being put in place. So, and I'm not putting a time frame. Whenever the permit is issued, the permit's issued, and then lawful use can occur based on whatever permit is issued. All right. Does that get us does that cover all the issues that have been alleged in the notice of violation? Okay. Then I will sign that order. And is there anything else to come before me this afternoon in terms of this case? No?
Some people trying to ask questions over there.
Well, I'm not
Okay.
wanting to take public comment at this point. I've made my ruling. So then if there's nothing else, then we stand adjourned. It is 1:36.